Hi, good morning everyone. Can you hear me? First hurdle crossed, everyone can hear me. Fantastic news. So I'm Nicole Lee, and I'm one of the solicitors at SEN Legal. Just a little blurb about me before we get going for those of you who haven't worked with me or met me before. I'm based in the Bury St Edmunds office and have been with SEN Legal now since January 2015. I relocated here from North Wales, so for that reason I have a special interest, in addition to the normal tribunal work, in appeals to the SEN Tribunal for Wales. So if you're dealing with a Welsh case, you'll probably be dealing with me. And within the practice, I also deal with the social care type stuff. So if you're dealing with a case which has a large social care element or is entirely social care, you'll probably be dealing with me direct. So to get going, I'm now going to try and share my screen, which I hope will work. And I believe I'm now screen sharing. Yes, and that you can also, yes, and we can all see the right thing. Perfect. So to get going today, I'm going to be speaking to you about education otherwise than at a school, which I very wittily entitled, "If the shoe doesn't fit, don't wear it." The legislative basis for education otherwise than in a school, it could previously be found within the Education Act of 1996 and is now set out in the Children and Families Act of 2014 under section 61. And that is called Special Educational Provision otherwise than in schools, post-16 institutions, etc. Hugely catchy and long-winded, so I'm not going to call it that today. I'm going to call it education otherwise. In terms of education other than at schools, it really is the Ronseal of titles. It really does what it says on the tin, and it is educational provision being made for children and young people outside of a more traditional educational setting or institution. So it's for those children who, for a variety of reasons, cannot, their needs just completely exclude them from being able to attend a more traditional setting. So looking at education otherwise and where it comes from, is it a sign of the times, I guess, is the first question that we ask ourselves. Now, education otherwise was available under the Education Act. It's been around for a long, long time. So it's not necessarily something which has arisen in the immediate future, in the immediate present even, but it is something that's definitely becoming more and more prevalent in the field of SEN. And to understand that really, we only need to look at what we see online, what we hear in our roles day to day at schools, as experts, as specialists in the field. So there's no end of ombudsman decisions, Ofsted reports, legal challenges, articles which tell us that there are ongoing systematic failings at all levels really, where children and young people with special educational needs just aren't receiving the provision that they need, either at the right time or sometimes at all. And just to give you an idea of the scale of the problem, I very helpfully dedicated one of my lockdown evenings to reading all of the decisions in the Local Government Ombudsman Archive for 2019 to 2020. So these run from April 2019 to January 2020. And there are 236 decisions in there, and I've read them all for you because I'm very helpful like that. And of those 236 decisions, 147 of them relate to a failure to provide provision either in a timely fashion, in accordance with the deadlines as they were pre-COVID, which obviously Hayley talked with you about this morning. And when you actually look at that figure, that's 63% of all of the decisions in that archive relate to a failure to provide provision in a timely fashion, if at all. And then a further caveat to that is that the bulk of the decisions that aren't reflected in that number are ombudsman decisions, which really are non-decisions because the parents either had a right of appeal they could have utilised or a right of appeal they utilised, and so the ombudsman couldn't consider it. And when you look behind those cases, the reality of the position is LAs were never overly good at getting provision in the right place and at the right time, and that the bulk of those cases probably have a issue with the delivery of provision in a timely fashion behind them. And many of those complaints, once you actually break them down and you look at what the parents were complaining about, really sadly reflects that that failure to get the provision in place at the right time when it was needed has resulted in that particular child just simply being able to attend a school. And they can't get them there, the anxiety is too high, the negative associations are there, and they're really, really struggling to get them to school at all. And then even more hot off the presses for you, at the beginning of May, the Department for Education published sort of snapshot statistics which related to children with EHC plans. So it was only children with plans, not children without them. And it looked at what was going on for those kids, rough numbers. And in relation to, you know, what these statistics tell us, overwhelmingly, it's that the formal education system just is no longer working for a growing number of children. And this is children with EHC plans, we have to remember. This is children who theoretically already have a legal enforceable document there to protect them and to make sure they're getting the provision that they need. And I will run through the figures now briefly. They are from a single day snapshot in January, so they are quite volatile. And on top of that, I would say these are local authority reported, and in reality, how accurate are they going to be given the local authority are reporting on figures that for children who aren't in a traditional education setting and whose needs aren't being met there. But basically what that snapshot data tells us is that at that day in January, there were just under 5,000 children with EHC plans who were awaiting a provision. And of those 5,000 children, 3,000 of them were not in a setting at all, so they were at home. And of the remainder, they were in a setting which had been established as being unsuitable for them, and they were waiting for a suitable placement to open up, so they were just treading water. There were a further 4,600 children with education, health and care plans being educated via other arrangements, and that could either be other arrangements by the parents or by the local authority, and it doesn't really tell us much about what those other arrangements are. That could be formal education otherwise than in a school, or it could be something else entirely. We simply don't know. And these figures are slightly down on the last year, which might make you think, well, actually the system surely is working better, more children are getting into a school. But actually, for the first time, the Department for Education has published the figures for the children and young people with EHC plans who are in elective, and I use elective in the loosest sense of the word, home education, because in reality, a lot of those parents and those children and young people are being electively home educated because they just felt they didn't have any choice. And that was 3,000 children and young people, which is obviously a huge number of children and young people who are being electively educated within the home. And then possibly the most concerning statistic that came from the snapshot that I think is well worth a mention is that in January 2020, on that day, there were 8,000 children and young people who have EHC plans who had disappeared. They were not in education, they were not in employment, they were not in training, they were not in a elective home education arrangement, they weren't receiving provision made by a local authority through a different way. And that's a lot of children and young people, and we are yet to find out exactly where those children and young people have gone. And so, sort of building on what Hayley was talking about this morning, we need to think about COVID-19, and in reality, is this likely to have an effect on education otherwise than at school? And I think the answer to that is probably yes. It's really likely, in my view, that there are going to be children and young people who pre-COVID-19 were really struggling to get into school. The provision wasn't there. Their anxiety levels were probably extremely high. They might be being bullied within the education setting. And what we now have, due to COVID-19, is a total lack of provision, which obviously Hayley has already talked about, so I'm not going to labour the point. But much of the provision will have disappeared. They won't be accessing their peers, even the ones that are nice to them, the positive peers that they may otherwise have had. And also when you have been dreading going into your setting every day, when it's been a real battle to get you to go in every day, we need to consider actually what is the effect on those children of being able to be at home in a safe place with mum or dad, being educated in a way probably that's more suited to them than their educational placement ever was. And when the schools do reopen, in reality, how likely is it that those children are going to be able to reintegrate into the setting, particularly when we know there is going to be massive disruption, huge amounts of disruption when these kids go back to school. But all of that being said, and all of the data we've looked at, which says this is a big issue, actually, in terms of the number of appeals that we see as a practice, and we do see a huge number of appeals, education otherwise than at school probably makes up a very small fraction of those cases, very small indeed, actually. And we don't know exactly why that is. I mean, I would suspect, or I've certainly been told by some parents, that there is a belief that local authorities won't agree to it. I've been told by a client for whom I actually achieved education otherwise than at school, that their LA would not consider it. It was a policy. They would not agree to education otherwise than at school. Every child in their area had to go to school, or the parents, of course, would be threatened with enforcement action for failing to send them. So it could be that actually, looking at those figures from the Department for Education, there are huge tens of thousands of children and young people who are in fact being educated otherwise than at a school, who for a variety of reasons just aren't surfacing in the appeal system as frequently as we would expect. So now I want to move on to the legislative basis, the nitty-gritty of Section 61 and what it means. I'm not going to cover the Education Act because under the Education Act, things have moved on and we don't really have time. But basically, Section 61 of the Children and Families Act is very similar to the Section 319 of the Education Act as it was. And Section 61 contains the power, and we have to note it is a power, not a duty, for the local authority to make provision for a child otherwise than in a school or college. So what it says is a local authority may, not must, not shall, not will, may arrange for special educational provision. So it is a power, not an absolute duty. But in making that decision as to whether it may or whether it will make provision for a child in a setting otherwise than in an educational setting, the local authority have to consider whether it is necessary, and I've underlined the key words here on the slide, so whether it's necessary, but with the necessary being cast in terms of whether it is inappropriate for the provision to be made in an education setting. So therefore, if we are acting in cases, if we're supporting parents or children, young people, for whom education otherwise than at school is something that we're looking into, is something that's being requested, we need to be considering the legal definitions, both of inappropriate and necessary. So looking at inappropriate, what do the courts have to say about it? So SV Bracknell Forest is the first piece of case law I've got up for you. It, of course, dated 1999. It applied to statements of special educational needs, but it follows through and equally applies today. And this case, basically, it concerned a nursery age child who had a statement of SEN, and the parents wanted a home-based ABA program. And the appeal was dismissed. It was decided that that would not be awarded, and that decision was then appealed up to the High Court, where it failed again. But the judge, Baker J, did give us some guidance as to how inappropriateness can be established, and that can really be broken down into the first question to be asked is, what does the child need? So our first and foremost is establishing that provision. That's where our experts and our evidence comes in. What does that child need? And then following on from that, we consider, can that be provided in a school? And that needs to be fashioned in terms of that particular child or young person. What are their needs? What are we seeing? What does the evidence tell us? Can that provision be provided for them in a setting? There's a more recent piece of case law there, and Hertfordshire County Council, and what and Hertfordshire determined is that a child's anxiety and the anxiety alone, in fact, may mean that it is inappropriate for provision to be made within a school. So again, we're looking at our evidence. What about that child's presentation makes it inappropriate for them to be able to access a more traditional education setting? Why does educational provision need to be provided for them otherwise than in that setting? And if a child's anxiety precludes that, then that can satisfy the inappropriateness test. And now we've got TM and Hounslow. This case actually also concerns an ABA programme, obviously an ABA programme being a really obvious example of education otherwise on the basis that it is being fully integrated within the home environment. And in this case, the child had been following the home-based ABA programme since 2006, funded by the local authority. After which they'd issued a statement of special educational needs and named a maintained special school. So the parent appealed the decision and was unsuccessful actually at the first tier because the tribunal interpreted section 319, which is education otherwise as it was, to mean that it is only in circumstances where all or part of a child's special educational needs cannot be met in a school that it is appropriate for the provision to be made elsewhere than at a school. So that decision was then appealed off to the High Court and was dismissed, and the parents went at it again and appealed to the Court of Appeal. And at the Court of Appeal, the appeal was successful and the case remitted to the first tier on the basis that actually that interpretation of section 319 was incorrect. And the Court of Appeal held that to answer the question whether or not it would be inappropriate for provision to be made in a school, it isn't enough to ask whether the school can meet the need. So it's not just can the school meet the need, can the school make this provision? What we need to ask is would the school, that is to look at whether the school would not be suitable or would not be proper. And what that actually requires us and the local authority to do is to take account of all of the circumstances of each case. So that includes the child's background, their medical history, the particular educational needs of that child, the facilities that can be provided in the school or otherwise than at a school, and the costs, the child's reaction to the provisions, the parents' wishes, and any other particular circumstances that might apply. So what TM and Hounslow actually told us is that the circumstances that could lead to education other than at school being necessary are very, very broad and heavily dependent on the facts of each case. And that really hammers home the importance of the evidence that we obtain, what we put forwards to a tribunal, in a tribunal situation, how we draft our reports and really look at these children and their needs. Now, the second part of the test, which I've already highlighted, is the word necessary. And the word necessary, I imagine for a lot of you out there, will be a bit done to death, particularly for Charlotte, who actually is the person that brought about the bottom piece of case on my slide here. But basically, the definitions of necessary are set out there. So the word necessary falls somewhere between really useful and essential. Hertfordshire County Council then decided what is necessary is a matter to be deduced rather than defined. So that's the very fact-dependent, case-dependent analysis that we need to look at. And then rolling on to Charlotte's mention at the bottom there, basically Nottinghamshire County Council decided that all of the applications that had been there previously remain appropriate and that is what necessary is. It's not a concept that needs to be over-defined because the meaning of the word necessary will change. What is necessary for me may not be necessary for you, may not be necessary for the next person. So I think it's actually really good that Nottinghamshire came down and decided actually that necessary as it has been defined previously is how it should stay. Well done, Charlotte. So education otherwise than at schools in practice, and this is the question that most parents ask me actually when they do phone up and they're a bit unsure about where they're going, what they want, is the education otherwise for them, for their child. They ask me what might it look like, and the most obvious example of education otherwise is home-based education, where the child's needs mean that it would be inappropriate to be educated within an educational setting. So they're educated in the home, and an example that I gave previously is ABA programs. Home-based ABA programs as well is another obvious example of where provision would be provided otherwise than in a school or an institution. But then this leaves the question, which the courts did have to have a chew over, where a child is being educated otherwise than at school, what happens to Section I? And the reason that we needed to think about that is that Section 12 of the Special Educational Needs and Disability Regs makes it clear, or made it clear, that Section I of an EHC plan should set out the name of the school, maintained nursery, etc., or type of placement that the child or young person would attend. It had to be specified in Section I of the EHC plan because the regulations told us so. So what do we do with Section I, where the child was at home? And case law told us that a child cannot attend their own home. So Section I cannot name the child's home. And that case law was East Sussex and TW, which basically said that T's home is where he lives. It is not a proper use of language to say that his home is somewhere to be attended by him, nor is it a proper use of the word to describe his home as an institution. So that wiped out naming the home in Section I of an EHC plan. That isn't something that was appropriate to do. So what did we do with it? Now, the original position was really confusing, and I'm only briefly going to touch on it. And I'm going to focus mainly on Derbyshire County Council v EMDM. And basically, the previous case law held that where a child has been educated otherwise than at a school, we had to name an aspirational placement or type of placement in Section I of the EHC plan. And by aspirational, what they meant is that they would name in Section I a specific placement or a type of placement that it was hoped, it was aspired to, that that child or young person would be able to attend once the education otherwise had had its practical benefits, when they were ready to rejoin the sort of normal mainstream school life. I mean, and that was terribly confusing because it left us in a position where everybody had to agree that this setting wasn't suitable, couldn't be named, the child could not attend there, it would be inappropriate to do so. But then we had to name it in Section I. Which was just very, very confusing for everybody. And actually, I was acting in an education otherwise case when Derbyshire County Council and the change of the law came in. So I had to, during the course of one case, advise the parents about the aspirational placement, and then following Derbyshire, tell them actually that that had been removed. So under Derbyshire, and this is the most recent decision relating to education otherwise and how it works in the context of an EHC plan, Judge Wright held that the duty imposed on the local authority to secure that the EHC plan names a school or other institution or type of school or institution which the local authority thinks would be appropriate for the child or young person. However, if the local authority thinks that no school or other institution or type of either would be appropriate for the child, in my judgment, the naming duty under these sections, and thus in Section I of an EHC plan, cannot as a matter of law arise. And he described it as it being an absurd result if they had to, and I wholeheartedly agree with that. I think it was very, very bizarre that parents found themselves in a position where they have achieved education otherwise, where they've satisfied all of the conditions that it's necessary for the provision to be made outside of an educational setting, in that it would be unsuitable and inappropriate for them to attend the setting, to then have to pick an aspirational placement. And I think in practice, and what parents were very concerned about, and these are concerns that I shared, is that this would almost be inviting challenges in the future. If you have an aspirational placement named in Section I, who decides when that aspiration point has been reached, when that child is ready? And the likelihood is that both the local authority and the parents are going to have very differing opinions as to when that child would be ready to reintegrate back into a school, particularly given that education otherwise and the provision being made outside of a setting is likely to be really quite expensive to the public purse and for the local authority to maintain on an ongoing basis. So looking at the wider picture now, why might people be considering education otherwise? Why might we be looking, I know there are lots of experts attending today who will be assessing children. A lot of them are likely to have significant anxiety difficulties. And it's about thinking, why might we want education otherwise? How might it be justified? And I think what experience tells us is that trying to shoehorn a child into a school that's really not appropriate for them, been tried and tested, it's not going to work out for them, has the potential to have a really long-lasting, if not permanent impact on their mental health, their long-term prospects. And I've read many extremely sad psychiatric reports that detail exactly that say because of these child's needs not being met over a sustained period because of the situation they're in, actually they meet the criteria for a depressive condition, for an anxiety condition, and it's something that they're really going to have to work on in order to try to overcome those, if they're ever able to overcome them. But this puts parents in an impossible position, and one which I have a huge amount of sympathy for, where they are torn between getting their child to school, because we're all told we have to get our child to school, it's so important to get them into school. But that child may be crying and clinging to your leg as they're trying to put them through the door. And that's terrible. But in the alternative, what they're often receiving is letters from the school or from the local authority direct saying the attendance is down, the attendance is too low, and often actually facing enforcement action for failing to get their children to school. And that's a terrible position for them to be in, which feeds back into those the snapshot figures that the Department for Education released early on in May, because a lot of these parents and a lot of the parents that I speak to find themselves where they feel they have no choice but to electively. And remember those figures, there are currently 3,000 parents electively home educating their children. Because they feel they have no other choice. No other help is forthcoming. Education otherwise, their local authority policy is they don't deal with it, it won't be looked at, they feel they're not supported in it. So they bring their child home. But we need to think in the context of a child or a young person that already has an EHC plan in place, what effect that is going to have on the plan, and the pitfall, if you like, found in section 42.5 of the Children and Families Act. Because section 42, Hayley obviously talked about the notice that's currently in force, but we're talking about a world here post-COVID where everything's back to normal, and the absolute duty on the local authority to make the provision contained in an EHC plan. But what section 42.5 tells us is that where a parent has made what's called suitable alternative arrangements for their child to be educated, then actually the local authority are no longer under that duty to make the provision in section F of the EHC plan. So what these parents may find is that they have an EHC plan, probably extremely hard fought for. They bring their child home to electively educate them because they have no alternative. So how elective is that? And then find that actually in doing so, they are no longer entitled to any support from the local authority whatsoever. And they are very much on their own. And that's something when we are advising about education otherwise, when we are thinking about education otherwise, we need to be very, very careful to watch out for. And that is the whistle-stop tour of education otherwise. Obviously, if you've got any questions at all, please do keep asking them. I've seen them coming in through the morning, really, really pertinent questions, actually. Looking forward to getting down to answering them. But if you do have questions which are too specific or that we're not going to get to today, they're my contact details. Drop me a line, pick up the phone, give me a call, and I will be more than happy to help to discuss it with you.